Hi, my name's Katie, and I'm one of the attorneys at the Liker Law Firm. And one of the things that we're often asked is what will happen to your current accounts if you file for bankruptcy. Some debtors might be in a position where they are actually in good standing on some of their current accounts, meaning that their payments have been made on time and the minimum amounts are being paid. Oftentimes, an individual will want to keep a particular credit card or a store card, potentially for some benefit of having that card, or a gas card for emergencies or something like that. The long and short of it is that most credit card companies are going to cancel a credit card if you file for bankruptcy. Not all of them do, and that's certainly up to them. There's nothing we can really do to predict the behavior or stop it. The company cannot collect the previous amount owed, of course, but they don't really have an obligation to continue doing business with you. That's completely up to them. Some companies will have a waiting period and then they will continue to do business with you. Others, it's really hard to say for each particular lender. Debtors will commonly ask if a utility bill can be listed. The answer is pretty much the same as any other kind of debt. Any debt that is owed at the time of filing for bankruptcy should be listed, and that even includes student loans and things that aren't discharged. It must all be listed. Utility bills are dischargeable with the exception of the sewer district, which is considered a secured debt. If a utility is old or from a former residence, there aren't generally many problems. If the utilities are current, they must be listed. They are dischargeable, but your utility company may charge a deposit to keep that service in your name and going. So that's something you do want to be aware of. That is perfectly legal, and a number of companies do choose that option. The other thing to be wary of is if you have former residences, those might have been tacked onto your new bill, and in that case, even the debt from a former residence utility bill might cause you to require a deposit. Another commonly asked question is whether or not rent is dischargeable. Past due rent is absolutely dischargeable, and as I mentioned before, it should be listed if it is a debt that is owed. If it's for a residence where you no longer reside, there shouldn't be any issues. If you are listing back due rent for your current residence, you may want to talk to your landlord and consult your lease. Your landlord can't collect that back due rent, but may not be under any obligation to let you continue living on the property. So it's something you would certainly want to look into and potentially speak to your attorney about to get some more advice that'll be specific to your case. If you do have any questions or you'd like to set up a consultation, please feel free to contact us. Thank you.